Good morning, everyone, and welcome to our QCE Legal Studies lecture for Units 3 and 4 today. Thank you, everyone, for coming along. My name is Jess. I'll introduce a bit about myself in a moment, but to start with, let's have a look at ATAR notes. So we've been giving students resources since 2007 that are free and easy to access, and our lecture series is just one of those. We've got other examples here as well, so if you haven't checked out any of these things, do go to our website to find out more. Things like the Q&A discussions, study notes, articles, all those sorts of things that are definitely helpful, and I used myself when I was in Year 12 as well. A few other examples of things. We do have tutoring, and I am a tutor at TuteSmart. So if anyone is interested in that, please go and find out more on our website. And there are study guides, which I have written as well. I wrote the business and accounting study guides, and we also have a legal studies guide as well. And none of this would be possible without our sponsors, with our university partners. So thank you very much to them for making this possible. As promised, a little bit about me. So as I said, my name is Jess. I graduated in 2020, so it's been quite a few years now. I'm currently studying communication and journalism at the University of Queensland, and I'm in my third year there. And I love reading and writing. So subjects like English were definitely my thing at school. All of the humanities subjects, as you can probably guess, business, legal studies, accounting, those sorts of subjects. So a little bit about our lecture schedule today before we get stuck into it. So everything that we're doing today is based around the syllabus. So it will be Unit 4 that you're going to be up to now. So this lecture covers Unit 4 topics 1 and 2. That will be covered in either term 2 or term 3, depending on how your school works. And some of this content will be in your external exam, because your external exam actually covers topic 1 and topic 3. So a majority of today's content is in the topic 1 section. So a lot of this will definitely be relevant to not just your upcoming assignment, but also your external exam. And you'll be able to easily follow along with where we're at by looking at the progress bar down the bottom. So everything that's next to the human rights, number 1, that is all topic 1. So keep that in mind as we go through. And you can also see content block 1. All of that is from topic 1. There's a few things there from topic 2. And we're going to finish off today by looking at your argumentative essay assignment that you'll have to do for this unit, and some tips and advice. With that assignment, I do have some examples to show you what that kind of essay looks like. So hopefully that will be helpful. Okay, let's get started. So if you had a look at that previous slide, you would have seen you need to be able to describe different legal terms with your legal terminology. So human rights is obviously one of the most important parts of this. It's the name of the whole topic. So this is something that you really need to know. So human rights are the fundamental rights that all people have by virtue of being human beings, regardless of race, gender, age, nationality, or religion. So defined as the supreme, inherent, and inalienable rights to life, to dignity, and to self-development. So think about not only just the general meaning of what that was saying, but also the legal terminology that you can see in there. So, for example, you want to say fundamental rights. You don't want to just say human rights are the rights that all people have, and by virtue of being human beings. Things like the supreme, inherent, and inalienable rights. So having all that legal terminology is definitely important to make it a bit more sophisticated. And then human rights are defined internationally, nationally, and locally by various lawmaking bodies. So we'll see some examples throughout today's lecture of those bodies. And you can also see on the slide just some examples of human rights that we do have. And a lot of those, I'm sure, will resonate with you as human rights that you are pretty aware that we would have. States. So this is something that is going to come up all the time in this unit, and it may have done already in legal studies. So what you want to keep in mind is it's not like the state of Queensland; it's a country in the terms of human rights. So their countries recognized as having legal standing under international law. And in order to have that legal standing, you need a defined territory. So you can see that defined territory of Australia with where all our borders are. One government, and we have that one government. As we know, Anthony Albanese is our Prime Minister, and a permanent population. Definitely know that we have that since we are all here today. And they do have the ability to enter into relationships recognized by law with other states, so other countries. And we'll see throughout today's lecture that that is definitely the case for Australia. Something else that you will see all the time throughout this unit is these terms that refer to our legally binding agreements between the states. So we've got covenants and treaties, and they are often used synonymously, so meaning the same thing. So binding agreements between states that are formal, and they define and modify their mutual duties and obligations. So it's saying this is what we are signing up to, that we're promising we're going to uphold in terms of different responsibilities that they would have. So down the bottom there, you can see that there's actually another one as well. So convention is also a legally binding agreement between states. So if we look in more depth at that now, so again, the same definition, but a little bit more information as well. Conventions are stronger than declarations because they are legally binding for governments that have signed them. So think about that word declaration. If you declare something, meaning that you say it out loud or say it in writing, that doesn't necessarily mean you're going to go through with it. You could change your mind. So conventions are stronger because they are legally binding, and it's a bit more serious, I suppose. So when the UN General Assembly adopts a convention, it creates international norms and standards. So back to that idea of the duties and the obligations. So what are the standards that every state, every country needs to meet? And once that convention is adopted, then the member states can ratify the convention, and we'll have a look a bit more about what ratification means throughout today as well. And then if you violate those standards in the convention, then you can get censured by the UN as well, which I'm sure we have seen before. Now, throughout today's lecture, I've got some practice questions that you'll be able to do. If you pause the video, then you can have a go straight away. If not, you can use it as a bit of a revision tool in your own time, just to be able to test yourself to see if you have a good understanding. At the end of the lecture today, there is a slide that gives you either the answers or directs you to the slides where you can find the answers. So hopefully these practice questions will make this a bit more practical for you. Okay, so we've got different types of treaties. So we've got multilateral and bilateral. So hopefully we're familiar with those, the terms, so multi and bi. So both of them are formal agreements entered into by our nation states. So a nation state is just the same as a state. But they're basically just a different amount of states that are involved. That's the difference between the two. So bi means two, and multi, in general, it means more than one, but in this case, it does mean more than two. So more than two states are in that formal agreement. For multilateral and bilateral is just the two. So, as promised, we've got a bit more about ratification and signatories, and the difference between the two as well. So, when we have a signatory, that's a state that is in political support of a treaty and it's willing to continue that engagement with the treaty process. So, it's sort of like, I guess, an expression of interest of sorts. You're saying that you're interested, you're saying that you're willing to continue that process of following along with it, but you haven't yet actually got that legislation that's making it legal. So it's an intent, so that's important. It's about intent and it hasn't actually happened yet. So it's a signature that's submitted to the qualifying international body. So that's just meaning that whoever is in charge of that particular treaty, that is who you're submitting the signature to. And so, again, that important detail of in a state that's a signatory to a treaty, the treaty has not entered into force, meaning it's not become it's not been turned into legislation yet for that particular state. Now, ratification, on the other hand, occurs when a signatory country implements legislation domestically. So it is the process of full adoption of the obligations imposed by a treaty or covenant into Australian law by passing legislation through the federal parliament that is mirroring those treaty obligations. So whatever the treaty said that you needed to meet, the different standards and obligations, you're passing legislation that reflects that in that particular country. A bit of an example as well. So, Australia is a party to the United Nations Convention on the Rights of the Child, which was made in 1989. And therefore, each state in Australia, so state meaning our normal sort of definition of state in this case, has legislation protecting children to uphold the principles of the convention. So in Queensland, the Child Protection Act 1999 is an example of a piece of legislation that was passed to ensure that that convention was ratified. So what we've got here is different dates as well to keep in mind. So signing, where you express the intention to comply with a treaty. So in the case of this Convention on the Rights of the Child, in Australia, that occurred on the 22nd of August 1990. And then domestic legislation was implemented in December of 1990. So you've got three different dates there. One when it was actually made, 1989. One when Australia signed to express their intention to comply. And then one where it was ratified with that domestic legislation. So that's the difference there. Signing, hopefully, is a pretty easy word to remember, to understand that that means intention. Sovereignty, and this is quite relevant with the referendum that we'll be having later this year in Australia. So, sovereignty is the concept that a government exercises full control over the affairs within a geographical or territorial limit. So, for example, just the country of Australia, that's that geographical or territorial limit of what constitutes Australia. So that government can pass laws and enforce them within that area, like the government does in Australia. And it exists as an independent legal and political body. So it's not going to be influenced by someone else that's in charge. We are in charge here of our own laws. So we can see their sovereignty with our First Nations flag. So Australia claims sovereignty, as we just said, over the territory and the people. But also, some First Nations Australians say that they never relinquished their sovereignty. So we do have that debate because of the history of Australia with what happened with our First Nations people. So that relates to sovereignty and who actually has that control over the land and the laws and what happens here. Bilateral and multilateral. So those two we spoke about earlier, and you've got a few options about what they actually refer to. So have a go at that when you can. Okay, Bill of Rights and Royal Commission. Hopefully these terms are maybe slightly familiar to you after the time that you've had in legal studies so far. So, a Bill of Rights is a formal declaration of the legal and civil rights of the citizens of any state, country, or federation. So, it exists to protect those rights of individuals from being violated by the state or other individuals. So, it's saying this is what your rights are, and because that's written down in this formal declaration, that helps to protect you as well. So if you're not getting those rights, then something can potentially be done about that. Our royal commissions. So again, hopefully you've heard about these as well in the media. So the Australian system of government has royal commissions that are that highest form of inquiry. So it's independent of government and they investigate matters of public importance. So we've had royal commissions into banks, we've had royal commissions into aged care, all those sorts of important matters that required investigation. Those are the royal commissions. So royal commissions have those broad powers to hold public hearings, call witnesses under oath, and compel evidence. So that just means they have broad powers to seek and gain a lot of evidence from a lot of different people to inform that investigation. And once they have done all of that research, they make recommendations to government about what should change as well. So something that is directly from the syllabus that you'll need to be able to do is describe the main features of international law developed from the International Bill of Rights. And that consists of these three different parts. So we've got the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. The good thing about those acronyms is it's pretty easy to remember them, since they are just the first letter of every word. So don't think that you need to remember everything, because if you're given that in a question, then you'll be able to just tell based on the letters there. So to start with, the Universal Declaration of Human Rights. So it was written by representatives with different legal and cultural backgrounds, which is definitely important because different cultures have different ideas of what's right and wrong, and also different knowledge of legal systems. So having that representation that's diverse is definitely important. So it sets out those fundamental rights that require protection, and there's a range of those. So we've got civil and political, and that can include privacy and life and liberty. And then also economic, social, and cultural. So social security, health, and education are examples there. And you can see that that is an old photo from back in the day when the declaration was first made. So quite interesting to see it on such a big piece of paper. Now, explain the difference between signing and ratifying a treaty, which we went through earlier. So give that one a go. Our next one was the ICCPR. So that declares that all people have a range of, you guessed it, civil and political rights. So it is one of the components of the Bill of Human Rights. It was adopted in 1966 and entered into force 10 years later in 76. And its main focus is basic human rights. So there is overlap between these. So you would have seen we just spoke about, for example, the right to life was in the Universal Declaration of Human Rights. And so that obviously is very fundamental. So it does appear in multiple places, including here. Other things, fair trial and freedom from torture. So here it says most rights are not absolute and are subject to limitations for legitimate purposes. So that just means that that there are some exceptions, basically. So for the right to life, then there wouldn't be, I wouldn't have said exceptions to that. But when we get further into the lecture, we'll be talking about some implied rights in the Australian Constitution, and we'll be able to see a little bit more about how some rights are not always going to be able to be exercised because there are exceptions. Our other one with our economic, social, and cultural rights covenant. So that is covering a pretty broad range of things, and I have got some examples there that you can see. So things that maybe are less obvious than the ones we've gone through so far. So not only the right to training, not only the right to education, but also the right to training. Things like protection of the family unit, adequate standard of living, all of those sorts of things are going to be social. We've got economic with employment, working conditions, and the right to form a union. And then cultural is right to take part in culture. So Australia ratified that in 1975, but it hasn't implemented all the provisions in domestic legislation yet. We've got our refugee convention from 1951 and the protocol from 1967. So both of those are aiming to protect and support refugees. So they wanted to identify the conditions in which a person would be considered a refugee, which can sometimes be complicated, as we'll see in a moment. And they wanted to then provide legal rights to those people, recognizing that they have that right to seek asylum from persecution in other countries. So, all of those other rights in mind, if you have a right to life and a right to dignity, it all relates, it's all interrelated because refugees are people too, so they deserve those same human rights and that same treatment. So this family from Biloela, you may have seen in the news when the new government came in last year. They ended up allowing this family to stay because they had quite a hard time with originally not being assessed as refugees. So that meant that they didn't have the rights according to this convention and the protocol. And that was able to be used as an argument by some politicians to say that we didn't actually owe them any protection. So there is that difference between refugees and asylum seekers. A little bit more detail on each of those. So you may be wondering why there's two of them and what the difference is with convention versus protocol. So convention, that one came first. It elaborated on the Universal Declaration of Human Rights. So again, we can see that it does have overlap between the two, between lots of the different conventions that we have. One of the core principles was non-refoulement. So that sounds complicated, but it's simply just that idea that the refugee shouldn't be returned to a country where they do face those serious threats to their life or their freedom. Also, the arbitrary detainment is illegal, and public education is something that all refugees are entitled to. So this is where different countries, including Australia, will have some controversy around how refugees are treated. So in Australia, a lot of our refugees are on Christmas Island and things like that. And so there are some questions sometimes around whether they are being given these rights that they are entitled to. Now, the protocol, it broadened the applicability of that 1951 convention. So something that was in the convention was some time limits and geographical limits that made it a little bit more complicated. That is just in regards to Europe and the war over there, and it was limiting things in terms of what happened before and what happened after the war. So that's a little bit more detail than you would need to know, but that is something that you can look at further if you're interested. Another one, the ICERD with elimination of all forms of racial discrimination. So that's 1966, and as we can tell from the title, we want to eliminate racial segregation, criminalize the incitement of racial hatred, and promote understanding and tolerance. So we don't want to be segregated. We want no racial hatred, and that needs to be a crime. And then understanding and tolerance is what we want as well. The elimination of all forms of discrimination against women. So that's obviously outlining non-discrimination requirements and women's rights, with emphasis on political life, representation, and the rights to nationality, education, employment, and health. So a few main features include substantial equality, non-discrimination, and state obligation. So if we're wondering a little bit about particularly the first one and the third one in that list, we've got a little bit more information here. So substantive gender equality requires that education is interpreted according to the broad context or the realities of women's disadvantages and the impact of those circumstances. So, taking in the full situation to determine what equality really is. And state obligation is that concept that a state who is party to the convention is legally obligated to take all the appropriate measures to eliminate discrimination against women. And not only do that, but also advance gender equality. So some photos here of back in the day when this was first coming into power, with the women on a panel there who were part of all the decision making. We spoke about this one earlier, the Convention on the Rights of the Child. So a main feature is non-discrimination. So all children have rights regardless of race, color, sex, language, religion, political or other opinion, etc. So if we think back to the human rights definition earlier, it also listed those different aspects. We have human rights regardless of all of those things, and it's the same for children in this convention as well. So children's rights in the convention include the right to be treated fairly, and have a say about decisions affecting them, live and grow up healthy, be safe, have an education, and play and have fun. So those things might interest you as well. Just thinking, since we're all young, understanding what our actual rights are is quite interesting. And some more specific examples from Australia we have here. So devotion to the best interests of the child. So for things like when you have family law and determining things like custody, this is something that's really important. What is in the best interest of the child? And then respect for the views of the child, which is quite an interesting one. So children have a right to express themselves freely on matters that affect them and have their views taken seriously. So just because they're children doesn't mean that they shouldn't be taken seriously. And then just those basic things again with life, survival, and development. So in Australia, we don't actually have the Convention on the Rights of the Child embedded in our domestic legislation framework. Some child's rights issues that we do have. So something that's in the media at the moment with the age of criminal responsibility in Queensland, they're changing some laws around that. But at the moment, children as young as 10 can be arrested and jailed, which is quite young, according to the UN, who has called for the age to be raised to at least 14. child labor. So you can't just get a job when you're 5 years old or something. So you must be 15 to enter the labor practices. There are some exceptions to that, like the entertainment industry, but in general, it is that 15 years. And the right to get an education as well. So school is mandatory. And if you don't go to school, then you will be sought out by the various people who are monitoring that. You can leave school before 17, but there are requirements for that as well, with you needing to be working or studying at TAFE, for example. So there are exceptions, but in general, those are some of the issues that we have, contentious things in Australia. So you'll need to be able to explain a range of different things in paragraph sort of form. So the way that I've done this is giving that sort of paragraph, so you can understand how you might answer explanatory kind of questions. So if it's a little bit text heavy at the moment, then hopefully it will be helpful for when you're potentially using these slides later on to study. So this one, we need to explain the process by which the treaty obligations translate into domestic law through accession or ratification. So ratification, we've already covered that full adoption of the obligations imposed by the treaties. Accession is something that we haven't spoken about yet. Now, that is where a nation state enters into a treaty that has already been formed after it has been negotiated and signed by other states. So it has that same legal effect as ratification. It basically just means you we're a little bit late to the party, I guess, and you've done it later than other people, other states. The role of reservations. So this is something that is relevant to Australia as well, and we'll have a look at an example in a moment. So when you're negotiating for a nation to sign a convention, covenant or treaty, whichever word, um, it's possible to I guess, have some reservations in terms of no, we don't want to do that particular part of the convention. So if there's some parts that the state doesn't agree with, then they can sort of exclude that from the overarching thing that it's signing. So for the ICCPR, it's binding on states that ratify it. And Australia became a signatory in 1980, but it's reserved certain rights in relation to some of the provisions. So, for example, Australia didn't agree with the provision that all juvenile offenders must not be held in custody in adult prisons. So, that sometimes does happen in Australia. So, it made sense that they decided to make that one of their reservations. So, that means that when that does happen in Australia, they're not actually breaking what they agreed to, because they do have that reservation in place. So it definitely serves an important purpose with situations like that. So a full definition as well, in order to be able to explain the role of reservations. So a unilateral statement made by a state where it's saying that it's going to exclude or alter the legal effect of certain provisions. So the example I just gave you was excluding it, and it can also be altering it slightly as well. So that just means that the role, I guess, of reservations is just to allow that state to accept the treaty as a whole, but allow it to not apply those certain provisions that it doesn't agree with. And it can actually occur at all of those different stages of the process, when it's signed, ratified, accepted, approved, etc. All of those different stages, it can be applied there. There are some restrictions, so it must not be incompatible with the object and purpose of the treaty. So it can't be totally unreasonable if the treaty is wanting to protect, for example, education, then your reservation can't be totally against that idea of right to education. And then a treaty can actually prohibit reservations or only allow for certain ones. So it's definitely not just a pick and choose situation. There is a lot of structure involved in reservations. Explain the effect of the Human Rights Act 2011, so parliamentary scrutiny. So there's two processes that are important for you to know about this. The first one is the requirement of a statement of compatibility. So that's providing an assessment of the compatibility of the proposed legislation with the rights and freedoms recognized by those 7 human rights treaties that Australia has ratified. So when something comes up, it needs to be in line with the human rights treaties that Australia has already ratified. So you need that statement of compatibility to sort of prove that, I suppose. And then that allows potential reconsideration and possible amendment of those things if they are found not to be compatible as well. And then the idea of the Parliamentary Joint Committee on Human Rights, it has a bit of a gatekeeping role. So it's going to examine bills and legislative instruments and acts for compatibility as well, with those human rights, in all those other treaties. And it's also able to conduct inquiries into any human rights related issues. So basically, human rights need to be considered whenever you've got any policy or any legislation. So these ideas, this act is ensuring that you've got that compatibility, those provisions that are making sure that human rights are always considered. Sovereignty is something that we have already looked at. We use the example of First Nations peoples as well. And then sovereign equality is the concept that all sovereign states are treated equally in international law, and their right to make laws for their own territory will be respected. So just because a country might be larger or wealthier, or anything like that, doesn't mean that it has any more rights or any different rights to any other state, any other nation. So, yeah, that idea of we're all equal, sovereign equality. Political independence. So, within the bounds of a state, so like the boundary of Australia, for example, the state has the right to an independent political system of its own choice, and should be free from interference from any other state in how that is exercised. So we may sometimes wonder how other countries are allowed to have the different political systems that they have, which allow sort of, I guess, not so nice things to happen, or people to not have the best quality of life. And I guess that can be related to provisions like this, where different states do have the right to make their own choices in regards to what is considered their territory. Now, territorial integrity. is that idea that a state has the right to its own territory and another state shouldn't do anything to infringe that right. So Australia can't go to any other country and try to change things up. It's all that state's right to determine what happens in that territory that's theirs. Explain the role of reservations. Hopefully, that's something that we are now pretty clear on. And have a go at that when you can. We've got some specific articles from the United Nations Charter that is important for you to know. So Article 2.1, 2.4, and 2.7, they are all listed in the syllabus. So Article 2.1, it's confirming that equal sovereignty of all members of the United Nations. So you'll see going through these that the rights that we just went through, political independence, equality, sovereignty, etc., they are related in these articles here. So that first one, sovereign equality. 2.4 is use of force or threat of force against the territorial integrity or political independence of any state should not occur, basically. And the only exemption to that is Article 51, where we can use force if it's self-defense. So those ideas of territorial integrity and political independence are in that 2.4 article. And 2.7 is the independence of states from UN interference, specifically in domestic matters within a state. And exceptions to that are when it's potentially deemed a threat to international security. So that's why, a lot of countries have rights to their own government, their own territory, and that's why I guess some things happen that we don't have much control over. Explain the role of the UN, its agencies, and other organizations. So there are quite a few organizations that are part of the UN. So the UN, in general, the role of that body is to maintain international peace and security, protect human rights, deliver humanitarian aid, promote sustainable development, and uphold international law. So if you're not familiar with the history of that, it was formed after World War II because they recognized the awful effect of that war and they wanted to prevent that kind of destruction from happening again. A list of the agencies that are part of the UN. So we've got the World Health Organization to begin with. So as we can tell from the title, this one's one of the more obvious ones. It's wanting to coordinate action on international health issues, sanitation, and diseases. So that is an organization that we might have heard of during the height of the COVID pandemic. So the attainment of all people of the highest possible level of health is the target of that organization. The International Monetary Fund, they want monetary cooperation, secure financial stability, and promote those things that go along with that. So high employment, sustainable economic growth, and reduction of poverty as well. So they give advice and they negotiate and they assist states on financial issues. So it is independent, even though it does have that formal relationship with the UN. Now, different to that is the World Bank Group. So, 5 international organizations that make loans to developing countries. So, it is like our normal kind of bank, but it's giving loans specifically to developing countries. So, it focuses on poverty reduction and the improvement of living standards by providing low interest loans. So, unlike our sort of commercial banks, it is wanting to, I guess, be more charitable by giving the most low interest loans that it can. And then also just grants as well, interest-free credit, things that the country doesn't have to pay back at all as well. And the things that those countries can use that money for. So again, all of those areas that relate to our fundamental rights. So we've got rights around the education, health, communication, etc. So the World Bank Group is giving money to those countries so they can improve in those areas and therefore hopefully protect their people's human rights in those areas too. The UN High Commissioner for Human Rights. So they coordinate human rights activities and they supervise the Human Rights Council, which is in Geneva. So they're working to protect and promote human rights that are guaranteed in the Universal Declaration of Human Rights. And they also want new rights as well. They promote new rights that they see as being important too. The UN High Commissioner for Refugees, someone that that relates pretty strongly to what we looked at before with the convention and the protocol. So they lead and coordinate international efforts to protect refugees and resolve any refugee problems. So they are basically helping those people who need it to find the safe refuge and have that option to return home, to integrate locally, or to settle in a different country altogether. A practice question. So, which of the following is not one of the rights of states? So, this one might be a bit tricky because um, we do want all of these things in that list, but in terms of the actual rights of states that we've been through today, one of them is incorrect in that list. The Magna Carta from 1215, which is hundreds of years ago now, but it actually is still very relevant. So, interestingly, it provided quite a few rights that we now see today, that we see as being quite sort of, I guess, basic. So it provided a modern platform to the provision of human rights and the development of a constitution. So it is a document that's listing the different human rights. So it's considered pretty much a cornerstone in the English speaking world around human rights. So, an example of something that it has in it that resonates with us, I'm sure, is that idea of innocent until proven guilty by a jury of peers, and also the right to bail as well. So, it advanced the ideas of freedom, justice, and the rule of law. So, all of those things, like a right to a fair trial, to not be held imprisoned without the prospect of a fair trial, all of those things came about originally in the Magna Carta. The Racial Discrimination Act. So now we're going through some human rights in specific legal documents. So we've had the Magna Carta, and now we've got these various discrimination acts. So as we go through, hopefully you can think of some pretty logical examples of these sorts of discrimination, and what these discrimination acts are trying to work against. So racial discrimination is promoting that idea of equality before the law for all people, regardless of all the different things related to race. So race, color, national or ethnic origin. So the Act promotes human rights and fundamental freedoms in all of those different areas: political, economic, social, and cultural. So, for example, the right to vote, the right to education, and the right to freedom of thought, conscience, and religion. So, these things might seem pretty obvious to us now, but some time ago, I guess, there was a lot more segregation, and you didn't necessarily have these sorts of rights. So it's all, I guess, a work in progress. Our Sex Discrimination Act from 1984, it's promoting the human right of freedom from discrimination again, but this time on the grounds of sex, sexual orientation, gender identity, etc. So keeping in mind that it's quite wide ranging, I suppose. It's also your marital status, whether you're pregnant or not. So all of those different aspects come under that act. The Disability Discrimination Act, and we do have some examples for this one as well. So freedom from discrimination in regard to having a disability. So it's protecting people in a range of areas. So employment, education, access to services, facilities, and public areas. So it's making that unlawful. Discrimination in those areas is unlawful. And it's promoting equal rights, equal opportunity, and equal access. So if we have a look at some examples of disability discrimination as they may occur in real life. So a school policy not allowing students with disabilities to go on excursions. So if the school deemed it too tricky to accommodate them and they didn't allow them to come, then that would actually be discriminating against them based on their disability. And you've got some other examples there related to employment and other sort of social and service related situations. According to territorial integrity, and we've got a few options there. So it might be a little bit confusing because all of these mention the idea of territory, but only one of them is our answer. Describe and explain the Australian Constitution. So this again is strongly related to the referendum that we're having this year. So a referendum changes, if it's successful, it changes the Australian Constitution. So in this case, we're looking at the foreign affairs power in section 51, and that section's role in protecting express and implied human rights. So I mentioned something earlier about us looking at this in relation to having absolute rights. So that's something that we'll speak about in a moment. So section 51, under this foreign affairs power, the Parliament has the power to make laws for the peace, order, and good government of the Commonwealth with respect to external affairs. So that means that they can make some laws that are faithful implementation of international treaties, and thus they're protecting express and implied human rights in Australia. So any laws that they make have to still be in line with treaties that they have signed and ratified, but they do have that power to make those laws. So, an example here. So, in Commonwealth v Tasmania from 1983, the Commonwealth had the power under Section 51 to stop the construction of a dam based on Australia's international obligations under the World Heritage Convention. So, making that decision based on needing to be in alignment with those other international obligations. So, whenever the Parliament is making a decision, they need to consider those other things that they've already signed. So, some examples of express rights. The Australian Constitution has 5 human rights that are expressly stated. So the right to vote, and we've got all the different sections where you can find these as well. So the S in human rights, you might see that a lot. It'll always mean section. So the right to vote, the protection against acquisition of property on unjust terms. That one might be a little bit less familiar to you. The right to trial by jury, freedom of religion, and prohibition of discrimination on the basis of state of residency. So the express enshrinement of these human rights is protecting these human rights for the people of Australia, and it's also prohibiting any Commonwealth laws that go against them from being passed. So that's the idea of the Australian Constitution, and that's the idea of referendums. So it's really tricky to pass a referendum, and it's really tricky to go back and change anything as well. So that's why they need to be taken so seriously. Legislation can be just changed when a new government comes into power, or a new representative has a different view on the topic. But the Australian Constitution, it's all about referendums. So some implied rights, and these are the ones that would not be absolute. So we've got an example there from Lang v Australian Broadcasting Corporation. So they found that the right to free speech, freedom of communication on the government, is actually limited. So it's still a right, but it is limited, so not absolute. Because it has to be necessary for the effective operation of the government. So if it's not necessary, then that's one of the instances where you don't have that right for freedom of political communication. And other ones, free speech and democratic representation as well. So they are implied because it's about interpretations of the Australian Constitution, so they're not specifically stated or outlined. So you'll notice that we are now onto the effectiveness of international law. So we are now on topic 2. So this will only be relevant for the upcoming assignment, the argumentative essay, and it won't be covered in the external exam. But everything that we've covered up until this point is something that could come up in one form or another in your external exam. So in this case, we've got monitoring and reporting system for the United Nations. So the United Nations is required to report on each nation state's performance in how they uphold the different obligations that they have under international law. So Australia is actually required to periodically report to the UN in relation to its its performance as well. So Australia engages with a review system, and basically they review how we're doing with our human rights and how we're meeting those. And we also have recommendations that are given based on a report as well. So using at least two examples, explain the difference between express and implied human rights. So try to think of one example at least of each, to help you in your explanation of the difference between them. And remember, where are implied and express human rights actually spoken about? What is the name? You need to remember that name as well. That's what I was speaking about in relation to the referendum. Special reporteers are independent experts who are responsible for monitoring specific human rights and reporting their findings to the UN General Assembly and the Human Rights Council. So it sounds like a scary title, but I guess you can think of it as they're reporters. So they are monitoring and reporting their findings to the relevant bodies. They're appointed to examine the general human rights situation of a specific country, or to study specific thematic aspects of human rights at an international level. So it could be at a country level, or it could be taking an aspect of human rights, like the treatment of women, or the treatment of children, and looking at it from an international level, with that aspect in mind. So they have various functions. So they actually respond to individual complaints. They conduct research studies. They provide advice on technical cooperation, and they visit the countries as well to undertake research there, and assess specific human rights situations too. So, in terms of our complaints system with interstate complaints, they are made by nation states regarding another nation state. So, that's just the meaning there, interstate, that has signed and ratified the same treaty as them. So, both nation states need to have signed the same treaty, and one state is lodging a complaint against another state about the fact that that state has violated human rights, allegedly, in some way. So the process for doing this is done by making a complaint to the specific UN body that oversees the matters relating to that particular treaty. So there's lots of treaties, and there's specific bodies that oversee the various ones. And then that will be investigated by that relevant body as well. So several human rights treaties contain provisions to allow nation states to do exactly that. So not all of them, but some of them allow those complaints. Ancillary bodies and individuals are our last two. So other organizations and individuals in the United Nations. So UNICEF is an example. And these bodies they monitor human rights through investigation processes. And they're all about looking into those human rights violations in their specific areas of expertise. So using at least one example, explain the Disability Discrimination Act. And if you're really keen, I would encourage you to, I guess, replicate this question, thinking about those other acts that we looked at as well. So the Racial Discrimination Act and the Sex Discrimination Act, for example, try and think of examples and explain the overarching idea of those acts. So we've got international legal institutions and their role in upholding human rights. So one of them is the International Court of Justice. So it has only got jurisdiction to hear disputes between nation states. So if Australia was having a dispute with New Zealand, that would be something that the International Court of Justice could deal with. So the role is to settle those legal disputes according to the principles of international law. So it doesn't set precedents which are binding on all nations. So if we think about what you would have done previously in legal studies, you probably would have looked at criminal law with precedent cases and things like that. So in this case, the International Court of Justice can't make those precedents based on its decision making, which are binding on all nations. It's specifically looking at the two states that are having a dispute at any given time. And then the International Criminal Court is quite different with its responsibility. So the crimes that they are looking at are, so that it's crimes, not disputes between nation states, but crimes of individuals. And basically those crimes are so awful that they can't be left to one nation to persecute. So things like genocide, crimes against humanity, and war crimes are examples of that. So it gets to a level where it's too serious for individual nations to be expected to deal with the crimes. So some treaties that Australia is a part of. So we have special obligations for these treaties, separate from just ratification. So some of them we have looked at already, and some of them we haven't. So the Hague Convention on Civil Aspects of International Child Abduction. So providing that way for parents to retrieve their children if they are abducted to a different country. So the thing to keep in mind with these is the relevance of this information that we're covering now in this topic to effectiveness of international law. Its relevance to you depends on the assignment that your school has made for your argumentative essay. So every school is going to have a different assignment. So some of these might be relevant to you depending on the sort of case study that you're given. But I guess the point being you do have that ability to research and to look back at notes and things like that to really understand whatever it is you need to for your topic. And now the remainder of the unit for topic 2 focuses on the ideas that are sort of throughout the different humanities subjects at school. So that ability to select information, analyze it, and evaluate it as well. So in particular for legal studies, it's evaluating the effectiveness of international law and creating that argumentative essay to argue your points. So in general, it'll usually be something that's not effective, and you'll be arguing why that's not effective, and then that allows you to then give your recommendations on what should change in the law to make it effective. So focusing on a contemporary legal issue which lists those different things that we've just spoken about. So like I said, those are examples, and it depends on what your school has come up with in regards to this. So you may be wondering what an argumentative essay is. And so we're going to look a little bit about that now, what it is, what your assignment conditions are, and some examples to give you a little bit of an idea of how to go about this. So hopefully you'll go through it at school as well, but this can just foreground that. So, an argumentative essay, now this definition is taken from the syllabus. An argumentative essay takes a position on a topic, so like a legal reform issue, decision, or policy, and then it's presenting arguments that support that position. So it can be structured either by presenting the opposing view first and then countering this view with stronger evidence, or vice versa. So you're basically going to be given some kind of legal issue, human rights issue, and you're going to need to argue the effectiveness of that the law that relates to that, and analyze it with the different aspects that are good or bad, and provide all of that information in that argumentative kind of format. So I guess you can think of it as being quite closely related to the persuasive sort of speeches that I'm sure you're familiar with from all these years of English that you've been through. So it's just in essay format. So it's not going to be it's not going to be a speech. It's an essay with greater sort of formality, I suppose. So just like every humanities subject at school, it's again 1,500 to 2,000 words and 4 weeks, including 10 hours of class time to work on this. So use those words up is a tip that I'll give right now. There are plenty of things to say in each of these assignments for things like business, English, and legal studies. So I definitely recommend going and using all the words that you're given. A couple more practice questions as well. So the International Court of Justice, does it hear disputes between nations? Is it the one that prosecutes those crimes like genocide and war crimes, or does it monitor the human rights and report to the United Nations? So I guess this is illustrating the idea that a lot of these terms are quite similar. And so even though you might know it, also actually being able to just tell the difference between really similar sounding things, make sure you've definitely got the right one. That's important for the external exam, of course. For the argumentative essay, you'll have open access to all the resources. Now, I mentioned the syllabus a few times today, and so that's the QCEE website. Now, I definitely recommend accessing that for all of your subjects. Every subject has a syllabus with all the information you need to know about how you'll be assessed and what you'll be assessed on. So you also have example responses. So example responses to tasks and example task sheets like this one, which are giving you that kind of idea of what the sort of scenario will be like that you'll be given. and what the requirements are for you in terms of responding to that scenario. So in this case, we've got an argumentative essay in response to the question, to what extent will the proposed Commonwealth Modern Slavery Act 2018 be effective in addressing human rights issues found in international supply chains? So, and then also one recommendation to further improve the human rights outcomes for international workers. So, in this, I suppose in persuasive writing, in English, you generally would have your 3 argument paragraphs that are talking just about why you are right. Sometimes you might have a rebuttal paragraph, but you're basically sticking to your argument with high modality to show that you're certain about it. In this, it's more analytical, so it's important for you to be discussing both sides of the story. So you can see in this question that it does say to what extent. So usually it's going to be somewhere in the middle. It's not going to be perfect, because you do need to make at least one recommendation, of course. So there does need to be some room for improvement. But usually it's got some value as well. So there are some good things for you to point out too. So all of those things, with what to include, selecting the legal information from sources on one aspect of modern slavery. So wages, conditions, etc. So you're narrowing it down because, of course, the Modern Slavery Act is going to be very broad with different slavery issues. So concentrating on one thing for your task. Analyzing one case study where Australian businesses have workers in supply chains overseas. So this is a research related task as well, with looking at finding examples to include. Identify applicable legal concepts within Article 4 of the Human Rights Declaration, and determine the nature and scope of modern slavery in your case study. So again, all of these sorts of terms with nature and scope, you can find them in the glossary at the end of the syllabus document. So if you haven't already visited the syllabus, I definitely recommend that. And then, of course, evaluating alternatives and justifying your recommendation with legal criteria. So the legal criteria part is important, as well. It can't just be it can't be non-legal. So a recommendation you could give could be a good idea, but it might not actually be legal. So that's something to keep in mind as well. So, like I mentioned, the QCEE has the syllabus. They have example tasks like the one we just looked at, and they also have example responses. So these responses will be labeled with how they were marked. So you'll be able to see the marking rubric and what it scored for each of the criteria. And it also has highlighting throughout to show you how the response correlates with the criteria. In this case, I've done my own highlighting, and you can see that there is a lot of it. This is the introduction from the QCEE example of this response. And it's responding to that example that we just looked at here, the Modern Slavery Act. So what it includes: explanation of the issue to be discussed, giving some context. You're stating what the essay will be arguing. So, for example, here you can see it is arguable how effective the bill is to address human rights in supply chains. So then outlining the essay as well, including specifying what the case study is. So in this case, they've chosen to focus on the fishing industry of Thailand for the case study. And they're explaining that this will be analyzed and evaluated and a recommendation will be given. So showing your knowledge of the general context, telling them what you'll be arguing, giving that outline of what the case study is, and using basically the words that are in the task sheet. You need to analyze and evaluate and provide a recommendation. So, your last practice question, question 10, what are the 3 terms that all refer to a legally binding agreement between states? Hopefully, this one comes to you pretty naturally by now. Some of them might be more straightforward than others, but those 3 words that have come up throughout today's lecture. Now, the thing about year 11 is that usually it gives you a really good idea of what will happen in year 12, and it's reflecting the different assessment tasks. So hopefully in year 11 you did get experience doing an argumentative essay, and at that stage it probably was on civil law, if you had the same experience as me. But it could have been on criminal law because different schools do different orderings of when they cover the content. So this is just from my year 11 civil law assignment, which was the argumentative essay genre as well. So mine was about negligence, and it was about a driving scenario. So giving information again about under Queensland law, this particular idea of negligence, I'm saying that just and equitable outcomes won't be achieved. So I'm clearly stating in that first sentence, what am I talking about and what is my position on it? Then I'm explaining again those ideas of what will be done in this introduction. So I suppose the difference between my introduction and the introduction of the other example was they provided a bit more description of the general sort of situation, with defining like globalization, for example. So you'll find that the parts that are in the body are going to be most important, because that's where all your analysis and evaluation comes in. But in the introduction, you will see, if you have a look at the example, QCEE example, you need the features and conventions of an introduction. I believe that's the wording. So, so keeping it short, to use your word count elsewhere, but still giving that idea of what will I talk about, what is my case study, and what is my position on the issue. So I figured that you'll be able to look for yourselves to see that QCEE example. So I decided to include more snippets from my essay from civil law, so you can have an example. So I have also done some highlighting as well, so you can see how I've approached it. So citing the different legislation is something that you'll need to do. So it could be, since it's human rights in this case, it could be treaties or convenants that you're citing rather than like it was for me. So I have explained what the requirements are for a negligence action, because if I'm arguing that the requirements don't lead to just and equitable outcomes, logically I need to explain the broad situation of how the current law works in order to then explain why I believe it's not effective, and then how it needs to be improved. So you can see the analysis here of I'm giving an example of why this is good. So it provides the opportunity for the matter to be resolved without going to trial. They have a compulsory conference system, but the power imbalance between the parties involved doesn't result in those just and equitable outcomes. And then delving into that even deeper, why not? So things like affordability, as well, and explaining that full situation. So you're really digging deep into why it wouldn't be just and equitable. Another body snippet and a conclusion snippet as well. So using a precedent case. So in your argumentative essay, you saw that you'll need an example of a scenario that you've chosen. So the example in the QCEE one was fishing in Thailand. So here I've got a precedent case, and then using that to explain what the law is. So according to this precedent, the standard of care owed by inexperienced drivers is equal to that of any other driver. And then applying that to the scenario as well. So my scenario, I had a 20-year-old driver who had only been driving for 2 months. So you may think they need more leniency in the way that they are seen before the law, but they are actually, according to that precedent, as responsible as any other motor vehicle operator for taking reasonable care to avoid injury to others. So yeah, you can see all of your ideas, you just build on them. So if you provide a precedent case, you then apply it to your case study in question. If you are claiming that, if you're explaining the current system and you want to say that it's not just and equitable, then you need to explain why and give a real picture of what that all looks like. Now, your conclusion, keep in mind that there are going to be big differences because this is the civil law example. But just in general, you're going to need to always have that idea of recommendations at the end. So here I'm saying greater emphasis should be put on settling matters prior to court proceedings. So I'm saying this current conference system could be broadened, and I'm giving an example of what it could be like. So it could imitate the alternate dispute resolution pathway. And why is this a good idea? This would ensure just and equitable outcomes since the power imbalance of parties would be offset. So that is an example of how you would conclude it, with wrapping everything up and providing your recommendations. So I suppose you can see that there's argumentative, because you are arguing the just and equitable outcomes in this case, but it's more formal and you're not going to be emotional like you would be in a persuasive speech. It's very factual. Those are the answers to practice questions that we've seen throughout today's lecture. So if you have a go at those, I would encourage you to do that before you look at these answers. And and then refer to the slides as you need to. So to finish off, we've got some tips and advice that I wanted to give you as well. So referencing is something that is really important for this upcoming assignment, as it will have been for many of the assignments that you've already done for legal studies and other subjects. So what I wanted to do was give an example of my system. And if you haven't mastered your own system yet, then you may choose to use this as well. I use this at school, and then I still have a similar system at uni as well. So people have different preferences for how they do this. I personally like to keep track of my references as I go, which everyone I think should do. But I like to do my formal referencing at the end after I finish the final copy of my assignment. So my logic here is your draft is exactly that, a draft, and it could change. So if you go to all the effort of putting formal referencing in to your draft, then you may have wasted a lot of your time. So I have a bit of a code system with tables. So if I find a source, then I put it in with the information. If you want to simplify this at uni at the moment, I tend to just have the code and the URL. And then when I'm doing my formal referencing at the end, I can go back to the URL and find this other information. So depending on how you want to do it, you could put all the information in there to begin with, or you could just simplify it and then need to go back later on. So if I've got reference A and reference B, etc., with that, then when I have my my tables with notes related to specific topics, so for example, press freedom is a topic, then I'm going to put that at the top of the table, and then I'm going to have the notes underneath with the corresponding reference. So it would look like this. I would have in the draft something like ref B for reference B, and then in the final submission, you would do the proper reference. So the thing about having some system like writing ref is if in your case you need to see how many words it is without the references, then you can do Control F, the shortcut on your keyboard, and search for in like open bracket ref, and see how many times that appears, and then subtract double that number from the word count to see what your word count is, excluding references. Hopefully that makes sense. So yeah, that is my system, which I find works. Even if you don't like that system, try to come up with one if you haven't already, because if you for these final assignments for year 12, it's important, and it's definitely important if you go on to further study as well. Plagiarism is a big thing at uni. So to finish off, some last tips and advice. So you can see a QR code there. If you want to access the syllabus from that, then you can do so. That'll take you directly to the PDF document. And you can use the syllabus to study for your external exam, and to also understand what's coming up with your argumentative essay. I suggest that you also read the example essay. You might think that it's not relevant because it's on a totally different topic, but it still will give you that idea of how it's structured, what the requirements are, and then also just understanding the actual criteria. So usually it's pretty hard to absorb what the criteria is actually saying. So being able to see how the example essay that they provide meets the criteria is something that I think you'll find to be really valuable. And then the sample assessment instrument, that just means like your task sheet with the instructions for the task. All of that is available on the QCEE website, and you'll be able to see all the subjects listed on the website with various tabs, syllabus tab, an assessment tab, that kind of thing. So in terms of the key skills and the key ideas to take away from today, so using legal terminology is something that's really important. So you will have seen at the start of the lecture, the syllabus actually says specifically you need to be able to define and describe these things using that legal terminology. So what are human rights? They are the fundamental rights, and they're inalienable, and all those sorts of words that you need to know. With assignments, especially when you have time to go through and proofread and edit, always check for grammar and spelling. I am a bit of a I'm passionate, I guess, about grammar. It's one of my favorite things. So that I think should be one of the easier requirements from the criteria to meet, because it is just about the way that you have been able to articulate your words. It's not your ability to analyze and evaluate and all of those things. So definitely check your spelling and grammar. Read it multiple times, and also take on any feedback from your teacher as well, who might point out errors too. And speaking about your teacher, the drafting process is really valuable. So by now, you should be only getting one draft. And I personally like to treat that as the due date for the whole thing. At my school, it was usually the draft was due a week before the final submission. So I would have the task as done to the best of my ability by that date, handed in, and then you're essentially getting feedback on your final submission, what you would think you would submit. And that can really show you where you're at. And hopefully that will mean that you won't need to change too much after you get your teacher's feedback. Like I just said, with the referencing system, keep track of your references. It can be a real hassle if you don't keep track of your references and you have to go back and find where things came from. Even things like page numbers, if you're quoting directly, there are actually quite a few rules around that kind of thing. It definitely gets a lot more serious with following those conventions when you're at uni. But if you practice it now, then it'll set you up for success for later on as well. Mention your legislation or your precedent cases, all those different things you can apply to whatever the scenario is that you choose for the assignment. And like I said at the start of today's session, keeping your external exam in mind is a really good idea. So, like I mentioned, we went through human rights today, and then effectiveness of international law. The human rights topic, number one, is part of the external exam, and topic 3 is also part of the external exam. which we didn't explore today since that's not until about October. So hopefully today's session was helpful. I encourage you to use the questions that I had on my slides as a bit of a tool for your external exam, and also just for your general understanding. The fact that you have already hopefully started doing topic 1, or you will soon, means that you will have a lot of time to work on that before your external exam. So just because you've got an assignment and don't need to memorize these concepts doesn't mean that you can't start doing that to take the pressure off before your external exam. So thank you very much, everyone, for today's session. Good luck with the rest of your studies, and hopefully I will see you in future legal studies lectures and potentially in other lectures as well. Go back and have a look at things with promo codes that we have on our website, because you should be able to get some free access to other resources like our study notes, which is definitely something that I would recommend because I did that myself in year 12. Thank you, everyone. Have a great day. Bye.